Retaliation for seeking justice, a thought experiment, the law tries to avoid. Let's talk about retaliation for seeking justice. Not slogans, not outrage, just structure. To understand the problem clearly, I want to start with a thought experiment. One that sounds absurd at first, but reveals something very real. The criminal court thought experiment. Imagine a criminal justice system with the following rule. A victim reports a crime. The case goes to trial. A jury hears the evidence, and then the jury returns a verdict of not guilty. Not because the crime didn't happen, but because guilt was not proven beyond a reasonable doubt. Now imagine this additional rule. If the jury does not find the defendant guilty beyond a reasonable doubt, the victim must reimburse the defendant for all legal expenses and financial harm caused by the prosecution. Pause for a moment. Ask yourself honestly. Would victims report crimes? Would witnesses cooperate? Would justice be served? Or would silence become the rational choice? Why this sounds absurd and why it matters. That system would be universally condemned. Why? Because the law understands a basic principle. Seeking justice cannot be punished simply because proof fell short. In criminal law, we understand that a not guilty verdict does not mean the accusation was wrongful. Failure of proof is not misconduct. Justice requires the ability to come forward without fear of retaliation. Now keep that principle in mind and look at civil justice. Civil courts quietly allow what criminal courts would never tolerate. In civil litigation, something very different happens. A person files a claim, they seek redress, they invoke the courts, and the system says if you are wrong, even in good faith, you may be held responsible for the other side's costs, counterclaims, and financial exposure. This is not hypothetical, this is routine. The result is simple, justice becomes a financial gamble. Threat of retaliation works even without action. Here is the most important point. Retaliation does not require a filed counterclaim, a sanctions motion, a court order. The threat alone is enough. If people know that seeking justice exposes them to asymmetric financial harm, most will never file at all. That is deterrence, not justice. The law knows retaliation is wrong, just not here across the legal system. Retaliation is explicitly prohibited in employment law, in whistleblower protection, in civil rights enforcement, in consumer protection statutes. The rule is clear. You may not retaliate against a person for asserting a legal right, even if that claim ultimately fails. But in ordinary civil procedure, this principle quietly disappears. Counterclaims are allowed, cost shifting is tolerated, exposure is normalized. The system pretends these are neutral consequences. They are not. Why the analogy to criminal law is fair. Some will say, civil and criminal law are different. That's true, but irrelevant. The principle at stake is the same. A system that punishes good faith attempts to seek justice will deter justice-seeking behavior. Criminal law recognizes this openly. Civil procedure does not. That is not because retaliation is less harmful in civil cases, but because it is more convenient to ignore. What this produces in the real world. Here is what actually happens. Individuals hesitate. Claims are abandoned, violations go untested, power goes unchallenged, silence looks like efficiency, and the system congratulates itself for resolving fewer cases. But fewer cases do not mean fewer wrongs. They mean fewer people willing to risk retaliation. This is not about protecting false claims. Let's be clear. No one is arguing that false or bad faith claims should be protected. Every system needs tools to stop abuse, but there is a profound difference between punishing bad faith and punishing unsuccessful good faith claims. Criminal law understands that difference perfectly. Civil procedure pretends it doesn't exist. The core principle the system refuses to state. Here is the principle that already exists everywhere else in law. Access to justice must be protected independently of outcome. If that principle is abandoned, rights exist only for those who can afford retaliation. That is not rule of law. That is risk management. Closing. A justice system should not require courage backed by wealth. If we would never hold crime victims financially responsible because a jury was unconvinced, we should question why civil litigants face retaliation simply for asking the court to enforce the law. When seeking justice becomes dangerous, silence becomes rational, and a system that depends on silence is not a justice system at all. End.